This is a messy employment discrimination case. Pro tip, as an employer, those are not words that you want to see a federal judge write in their order sending your case to a jury trial. But those are the words that SHRM saw, the Society for Human Resource Management, in a lawsuit against them by a former employee who sued them on the basis of race discrimination. Now, often in videos, I talk about management tips, what to do, not to do, and I will talk about those today. But I've been a lawyer, and I'm not a lawyer for SHRM or any of the parties in this lawsuit, but I like to break down some of these complex topics and take real-life lessons away from these. And the judge is right. This is a messy one. So I'll be breaking down this case and have lessons that every employer should learn, that SHRM hopefully has by now. As quick background, the case was brought by a former employee of SHRM who was a senior instructional designer. She worked for SHRM for about 4.5 years. When she was terminated from employment in September 2020, she filed an EEOC charge and eventually a lawsuit on the basis of race discrimination. She's an Egyptian black woman. Now, to be clear, SHRM denies these allegations, and they've said to media since this order came out that they're vigorously defending. But what happens is the lawsuit was filed and people exchange paperwork, have depositions, sworn testimony. And so what SHRM put in front of the judge is a motion for summary judgment, meaning that there's nothing that a jury needs to decide about facts. We can win this case just on all of our briefing. And then the plaintiff, the employee, gets to file a response. SHRM files a reply. So it's a lot of paperwork. So that's why it's taken 4 years to get to this point. But the judge in this case issued an order that was really telling. In part because very rarely do employment cases get to a jury. Often they stop, they're not even turned into lawsuits, or they may be settled, or often employers, especially in the US, win at summary judgment. But in this case, the judge said that there are issues of fact that a jury has to decide. And even more so, the judge said there's potential that this was done maliciously to the employee. And this is all by SHRM, which holds itself up as the leader in HR management. That's why this is so notable. But in this case, I'll talk about some of the takeaways that every employer should know about, and manager and HR. The first lesson is on performance reviews. Now, personally, performance reviews are the number one thing I've seen lead to issues in employment lawsuits, where an employee gets a performance review that you or I, or certainly that employee, would read and be like, they're doing great, and then they're let go shortly after for performance issues. That's what happened here. So this employee, on May 20th, her supervisor submitted a formal performance review rating that employee a solid performer or role model in every category, which are the top 2 categories in SHRM. That employee says she met with her supervisor and was like, okay, what's this piece of feedback here? And that piece of feedback said, as a senior instructional designer and having experience at SHRM, the organization greatly benefits from your creativity and institutional knowledge. As you continue to grow in your design experience, you'll be able to balance those pieces against timelines for improved efficiency and business impact. Now, if you hear that and you're like, what does that mean? The employee felt the same way. She testified that she asked her supervisor, what is this? Because to her knowledge, she didn't have any issues with deadlines. And that her supervisor said, oh, we were told that we had to give some critical feedback. Keep up the good work. While that's the employee's testimony and the employer and the supervisor haven't corroborated that, what's undisputed is that the employee was let go just 3.5 months later for performance issues, specifically deadlines that she was said to have missed. And we'll talk about that. But the issue for all employers is that it's so important that managers understand the point of a performance review. It's giving that feedback, so they should be able to stand behind everything they said. If someone doesn't have critical feedback for someone, they shouldn't be told to make it up just to put something on paper, but they should think about different opportunities. And if a manager says something like, oh, we just had to put critical feedback down, it makes an employee lose trust in the whole process. So there's so many lessons. And that lesson should not be a takeaway of just don't have formal performance reviews, because the data has shown organizations that moved away from those didn't see increased performance. They saw decreases. The key is to really train managers on performance management and ongoing communication. So nothing in that performance review or that happens at all in employment is a surprise. Now fast forward to June 2020, just a couple weeks later, when the employee reached out by phone to her boss's boss about concerns that she had about that boss, about her own manager. And there's some context behind this. So again, we're coming out of COVID. This was right after George Floyd. And her boss's boss had reached out to different employees to offer them support. And she said that her boss's boss had been her support, her safe person. So in that conversation, she talked about concerns that she had about her own boss, including that she micromanaged her. But first, let's talk about that. One of the aspects of micromanagement that she said is that her boss required her, this employee, to CC and include her on all emails with vendors, and also to include her boss in all of her meetings with vendors. There's a lesson in that. Often, when managers sense some sort of issue, real or otherwise, they take control by saying just that. CC me on all your communications, or run all your communications by me, or let me attend your meetings. Now, what that can mean is all of a sudden that boss, their full-time job becomes that employee's job, and you're having someone look over your shoulder. And that feels really micromanaging, because it is. And the employee said that her boss had said, well, you're not assertive enough in these meetings. But the ways to do that as a manager are to do things like give examples, give support, and teach someone, rather than just say, include me in every single thing, especially if an employee is working a lot with these outside vendors. So one of those lessons for managers is just that. If you're sensing some sort of issue and want to give feedback, the answer often isn't to hover over them and all of a sudden be like, run every single thing through me, never have a conversation without me, because it feels just like it felt to this employee, or then they may reach out to someone else to complain about that, or they may hold it internally while they look for other jobs. Now, one other very notable thing that the employee brought up in her June phone call to her boss's boss was that she specifically identified 2 white colleagues by name that she said the manager was treating more favorably than her. And this employee testified that she brought up race as part of this conversation. The boss's boss denies that. But generally, as part of leadership training, when you're taking in a concern from an employee, certainly if someone does bring up things like race, discrimination, those are characteristics or any type of protected class, age, gender, those things that you should be trained to say, okay, let me have someone look into that. I'll reach out to HR or whoever, and either they or I will get back to you on next steps so we can make sure this is looked into. Because even if you don't know exactly what's going to happen, that shows that you're taking it seriously. In a situation where an employee's complaining and they're identifying 2 people who are, this employee's in a protected class and those 2 employees are not, and she's said they're treated more favorably, my guess is that most organizations' training should be something that should be raised to HR to say, let me look into this and have them. But that wasn't what happened here. The boss's boss is like, hey, we got to get your boss in on this conversation. So she set up a Zoom call for the next day. So this employee would have to confront her boss and talk about these things and her issues. And that happened. She brought up the things like micromanaging. Now, in that conversation, the boss became emotional. She cried. She became defensive, as her own boss says. And her own boss said that was something to coach her on. That when an employee is raising concerns, especially doing that directly, it's important to listen and hear them out, rather than becoming defensive. Because absolutely, under human nature, if someone's criticizing you, you may feel like you're bristling. But as part of management and leadership training, I guarantee you, SHRM would tell you, it's important that when you say things like open door, you have these values, that managers should be able to hear that feedback. And if you're so emotional you can't respond in the moment, take the time to get back. But hear what people are saying and really reflect on it before you lash out at them. But that's what happened. It wasn't involved with HR or anything like that. It was individuals in this department having this conversation directly. Now, just over a week later, in the middle of June, the employee did undisputedly raise the issue of race in a conversation with her manager, asking me, would you treat me this way if I were a white male? And also, during a meeting with the boss's boss and HR and some individual contributors on employee engagement survey results from the team, she also then raised the issue of race and felt like she was treated differently than her white colleagues based on the issue of race. Another quick lesson is on employee engagement results. If you are having an employee engagement survey, communication is so important. So if it's anonymous, being mindful in your questioning and not asking things like, what department is this in? Because those can be giveaways. But also, if you're going to have follow-up meetings with people and talk about survey results, making clear of that and explaining that at the outset so people aren't surprised if you reach out later. And I haven't seen anyone raise that in this issue, but it is an important lesson, because when I saw that concerns about race were brought up in a meeting about employee engagement survey results, it made me wonder what the communications look like, or if people were surprised to have those follow-up meetings. Now, shortly after this call between the employee and her boss, where she raised the issue of race, her boss reached out to HR. She said she was a relatively new people manager, so she wanted his guidance. She reached out to someone who was a manager of employee experience, and he began to investigate this complaint. Now, notably, he swore that he's never in the past ever investigated a racial discrimination complaint. And others in HR were asked at SHRM, why didn't you consider an external investigator? Someone's raising the issue of race. And someone had testified that they didn't because they hadn't identified any external resources to do so. Now remember, this is SHRM, whose whole organization is about providing education and also certification of HR professionals. So instead of having someone externally, and I agree it can be helpful to have someone internally, but it should be someone that's really trained on looking into concerns and how you handle them. And again, this individual had never looked into a concern of race discrimination before. Now, whether you have someone internally or externally in charge of that investigation, looking into those concerns, it's important that that person be and appear as neutral, so as a fact finder, having conversations, not weighing either way, putting together what was said, what was verified by someone, what the documents say, all of that objectively. It's so important. But this person in HR has said that SHRM, like a lot of organizations, people have to wear many hats. And so while one of his hats was to be in charge of this investigation and have conversations, he also had a role in aspects of the employee's employment. So as things went on, the employee was given deadlines. And we'll talk about those 2 big deadlines for projects. Now, as part of it, she had reached out with some concerns and asking for help and had communications with her supervisor. At one point, she'd sent a communication to her supervisor. Her supervisor had forwarded up to more senior executives. A senior executive recommended that another work with HR, specifically the person in charge of the investigation, in crafting a response for the supervisor to send her employee. So, in short, you have a situation where someone in charge of investigating is also asked to give guidance on communications from the manager to that employee. The problem with that, is you can probably imagine, is that makes that fact finder not be quite so neutral. All of a sudden, they're giving advice on how to communicate with this person to put them at bay. Now, this HR investigator has said they don't explicitly remember giving advice on the supervisor to craft the email, but there's files that have their initials in it, this HR person's initials in it. And he said he just does not remember. Now, another problem is that this email where the senior executive is telling the employee's boss to work with the HR investigator on a response to the employee's email, is that senior executive says, I suggest having her confer with HR on the response to the employee's email. That email shouldn't go unanswered, true. But this offers an opportunity to get the right language on the table to correct her quickly, or to support an eventual case for termination. We want the right words in there. Now, yes, if someone is terminated from employment, it is important that communication be consistent, that what you're saying to that employee in the moment is the same thing that you'd be saying if eventually a case goes to trial about that. True. But when you're crafting those communications, it should be to help to support and communicate with that employee, not to craft them with an eye towards eventual termination. And especially when a message like that is sent, it suggests that you've had termination in your mind all along. And this is an employee, remember, that has raised concerns about racial discrimination and had sent an email to her boss outlining issues she was having with vendors to get these project deadlines completed. And the senior executive is telling her boss to work with HR to get the communication right. And the communication that was eventually crafted, which, again, reasonably appears with the initials in the file that HR, the investigator, had a hand in that, said that the deadlines that were at the end of the month were non-negotiable. And that was the communication sent, with, I guess, an eye towards termination of employment. So in mid-August 2020, the employee had reached out to her boss and pointed to issues with vendors delaying what they were supposed to do. So she was having issues meeting her own deadlines and asking her boss for help working to meet those deadlines. And her boss had then crafted this response, ostensibly with help of HR, the person in charge of the investigation, saying these were non-negotiable. Well, in that email, it did not say, if you don't meet these, you'll be terminated from employment. The employee was not put on a formal performance improvement plan, anything like that, saying that you'll be terminated if you don't meet these. But the employee, after getting this email about non-negotiable deadlines, had reached out again to a senior executive and had reiterated that she'd raised these concerns and felt micromanaged and was held to these deadlines, and said that she felt like it was retaliation. Now, this is very common in employment type of concerns, that if someone raises a concern, things can happen, and it feels and can be retaliation. And when that happens, it's key that that term retaliation or anything like that is taken very seriously. So ostensibly, this HR individual who had again been working on some of these emails and things, but also over the investigation, would have reached out to the employee and had been notified about this. Hey, we need to talk about this because now it's a concern into retaliation as well, not just the initial discrimination. But that HR investigator never reached out to the employee about this email that she'd sent. Never looked in further to whether there was retaliation that occurred. Never happened. Again, as a best practice, when people use words and things like that, taking it seriously, and as new things happen in the investigation, looking into those and having conversations to understand what's happened. Because otherwise, if you end up not responding to the person and they end up being, say, terminated from employment, it can feel incredibly unfair. Now, we know that the HR investigator was made aware of her complaint about retaliation because 2 minutes after the employee had sent that complaint to an executive, the executive sent it on to individuals, including the CHRO of SHRM. And the CHRO of SHRM sent that complaint by email to the HR investigator and also another woman who was a SHRM employee that the CHRO had involved to try to mediate between the employee and her boss. Now, they had said they didn't have an external individual help to mediate the situation because they hadn't identified someone with the right skill set who could do it in a timely manner. So they had this third party, a woman who worked there in organizational development. But that individual they said they picked because she'd mediated different things at work before, including in academic environments. But that woman has said she'd never mediated a situation where there were complaints about discrimination. This August 2020 complaint of retaliation, where the HR investigator never followed up with the employee to actually ask about that aspect of the complaint, wasn't the only lapse by SHRM. There was another complaint of racial discrimination when this is all happening. It was in July 2020 by a colleague, a black female colleague on that same team, about that same boss. And the HR investigator was aware of that in July. The Chief Human Resources Officer of SHRM was aware of that in July. And the Chief Human Resources Officer said that they would have expected the HR investigator to investigate that claim as well. The HR investigator can't remember doing anything about it. And that employee who made that complaint was fired 2 weeks after making the complaint. Another lesson is when you're doing things like an investigation, looking into concerns, it's possible that other people are going to have other concerns that pop up. Because often people are really afraid to raise those for good reasons, as people often see. But when other people in an investigation raise those, it's important to give those attention and treat those as additional reviews. There may be some overlap, but it's really important to follow through with them, to have consistent policies and procedures so that after the fact, you're not sitting before very expensive lawyers telling them, maybe I would have done different things in hindsight. So what happened with the termination? The court's order sending this case to trial spells it out in a way that might make you. So on August 19th, the same day that the employee raised a complaint of retaliation, in addition to her existing complaint of discrimination, that same day, paperwork was drafted up for her termination. And that paperwork was drafted up by the HR investigator who'd been looking into her complaints, who didn't reach out to her about this retaliation complaint. Now, in the depositions, and I've read through most of the depositions in this case that are on the federal docket, in it, this HR investigator says he was going out on medical leave, and so he wanted to do it just in case before he left, and so it was anticipatory, but that there were different situations being discussed. But a few things. One is, an investigator over a claim objectively should not be involved in drafting termination paperwork. Certainly not when that person has raised a retaliation complaint, even if they're going out. So that's just flat out a lesson. But also, again, there hadn't been a performance improvement plan or things of targeting this date other than August 31st was the date of these deadlines. So before August 31st, the employee did submit both of these projects to her manager. Now, in it, the manager has said that the projects weren't as complete as they'd like, and they reassigned them to 2 other colleagues. One of the projects was, even though they said it wasn't complete, was done, and the changes finished within a week after the employee was terminated from employment. But one of these lessons is if you have an employee and you're giving them certainly a deadline that could lead to the end of their employment, is to be really specific. Whether it's, these projects need to be done to our satisfaction, then have it done. But it also shouldn't be a gotcha. If on August 28th, or whenever someone submits projects and you're like, okay, but this isn't fully complete, having that conversation and talking through it and having glimpses of it beforehand. So they're not submitting what they may think is complete at the deadline, but you're like, no, that's not it. It's important to really be specific and give feedback along the way so a termination doesn't feel quite like a gotcha. And in the reason for termination, SHRM says, including in its documents, that the sole reason for the employee's termination was missing these deadlines of August 31st. When she did submit things, but they say what she submitted wasn't actually complete as they'd expected. But the HR investigator who'd been involved in this, in his deposition, he talks about how other factors leading to the termination of employment were things like communication and other factors like that. And so it's a problem if there are different people who've been at least involved in the situation who have different reasons for what that termination of employment is. It's important that not just for the reasons set out in this email of make sure we're setting up a good case, but to be really clear. Because most poor employment situations don't lead to litigation. But most of them can lead to a situation of someone that leaves and feels like they were treated unfairly. They're telling their friends and family what that experience was like, that those friends and family might rightly tell them to go find a lawyer. But overall, making sure that what you're saying actually matches what's happening, it's being consistent. So if someone is missing a deadline, well, when they submitted something that they say was complete and now you say it isn't, that creates issues. And so the judge absolutely agrees. I've hardly read a legal opinion that's more savage, I don't know another word, than in this opinion, because there's so many steps along the way. And in multiple of the depositions, there are people from SHRM that have said, other best practices could have been followed. The Chief Human Resources Officer of SHRM agrees that as an organization, SHRM should strive to be a model organization. But in situations of people raising concerns, not having them looked into, raising additional aspects of the concerns, never being followed up with. There are so many aspects of this case that are really important lessons for so many to follow. So again, I don't know that anybody's going to go through all the hours of depositions like I did. You don't necessarily need to. But the point of this video is to show what can happen in the workplace. Where it's situations of managers that give performance ratings that sound really great, and then terminate someone from employment just 3.5 months later, and it feels unfair. And in this, because it is SHRM and because HR was so involved, the judge has not only said that, yes, this case will proceed to a jury, so a jury will decide this, but also there are aspects of it that a jury could infer that SHRM acted maliciously toward her, with HR involved. And so, no, nobody is perfect and rarely will things go smoothly. But at every step of the way, thinking about how would this look or feel to a third party that doesn't know what I know? So when you're giving performance feedback, is this actually what's going on? And is this what you'd say later on under oath? Or are you trying to be nice in the moment and actually not doing that by not giving them honest feedback? Or are you bringing your own biases in? Are you being open to that rather than being on a call and becoming defensive when the employee starts to raise those concerns? So there's so many lessons in this. So I appreciate this video is longer than some of mine. Again, I could probably talk about what I read in this and my eyes boggling out. I mean, things like the employee had actually raised her concerns to Johnny Taylor, the CEO of SHRM, who she testifies says that, yes, SHRM has an issue with diversity and has an issue with the managers. So he wasn't surprised to hear that. That's what she said that she testified that he said. And a bunch of different aspects like that. Another white colleague of this employee who submitted a declaration, which is a sworn statement, saying that she definitely feels like this employee was treated differently on the basis of race, and that she had things happen, she missed deadlines, and she wasn't punished like this employee bringing the lawsuit was. And so this one is absolutely messy. So I appreciate you watching this. Hopefully the timestamps have helped. But it's just so important when things like this happen to reflect and take lessons that every employee needs to hear, including SHRM.